Good afternoon, guys. Um so here we are with business legislation semester 4, um, MBA students. And this will deal with, as the name suggests, the syllabus will be related to business law and various legal aspects of business. If you look into the syllabus part, then there are 5 units. First unit is laws related to promotion and incorporation, then laws related to contract, consumer protection law, environment protection and intellectual property rights, and fifth one is a law related to mergers and acquisitions. So these are the things we'll be covering. Now let's go to unit 1, which says laws related to promotion and incorporation. And the first, there are 5 points which we will discuss in this unit. First one is business law, introduction to business law. Second is Companies Act 2013. Third is what is company and company, what are about a bit about company. Fourth, formation of a company, and fifth, company documents. Now, business law. It is a branch of general law which is related to industry, trade, and commerce. So, what is business law? It is a branch of general law. And related to what? Related to industry, trade, and commerce. What are the objectives of business law? Define the rules of the business, that is the game. Enables enforcement rights. It enables various enforcement rights to the people, to the business people, to the people who are dealing with the business, to the consumers, etc. Achieve social justice. So, achieving social justice is another objective. Facilitates industrial growth. It is rigid and flexible both. So it is rigid as well as flexible. Rigid because it having some laws and they are rigidly followed, and there is flexibility when it comes on case to case basis. Scope. What are the scope of business law? Contract Act 1872, related to contract. Partnership Act 1932. Negotiable Instruments Act of 1881, which deals with the negotiable instruments. Sales of Goods Act of 1930. Companies Act of 2013. Insurance Companies Act of 1938. Banking Companies Act of 1949. Foreign Exchange Management Act of 1999. Carriers and Carriage of Goods Act. Commercial Securities Act 2015. Arbitration Act and Patents Act. So these are some of the scope areas of business law. Let us talk about the significance of business law, why we study business law, what is the use of business law. It provides regulation at various stages of the business. Framework for business activities. It provides framework for the business activities. It provides safeguard of legal rights. It to facilitate the business person to achieve their goals. Prevent concentration of economic powers, so that the power is distributed among various people. It does not get concentrated onto the hands of the few people. Helps in organizational growth. Helps in managerial decision making. It provides remedy for the breach of contract, and authoritarian scheme on how business is conducted. So it is also a guideline, a scheme of how business is to be conducted. So after a brief introduction of business law, let us move to Companies Act of 2013. The Companies Act of 2013 is an act of Parliament of India on Indian company law which regulates incorporation of the company, responsibility of the company, directors, dissolution of the company. The 2013 Act is divided into 29 chapters, including 470 sections, as against 658 sections in the Companies Act of 1956, and has 7 schedules altogether. The Act has replaced the Companies Act of 1956 in a partial manner after receiving the assent of the President of India on 29th of August 2013. The Act came into force on 12th of September 2013 with few changes, like earlier private companies' maximum number of members were 50 and now it will be 200. A new term of a one-person company is included in this Act, that will be a private company, and with only 98 provisions of the Act, were notified. What are the objectives of the Companies Act? It is to ensure standards of business integrity and conduct in promotion and management of the companies, full and fair disclosure, effective participation and control of shareholders, enforce proper performance of duties by the company management, to investigate and intervene in the affairs of the company wherever required, to protect the interest of the shareholders, to safeguard creditors. Corporate governance. What is corporate governance? It is the governance system of corporate which is expected for the free and fair operation of the companies, to attain the ultimate aim of social and economic policy of the government, to equip government with necessary powers to intervene in public interest. So that is, these are some objectives of Companies Act. Now let us know what is company. Company is a company formed and registered under this act, or an existing company, that is Indian Companies Act 2013, or any company act before this. If a body is registered under these acts, it is a company. It is an artificial person created by law, having separate legal entity with perpetual succession and common seal. What are the characteristics of a company? First of all, it is an incorporated entity. It is an artificial person. It is an incorporated entity. It is incorporated under a law. It is an artificial person. It is treated as a separate person from its promoters. Separate legal entity. It has separate legal entity when it comes to its promoters. Promoters are different from the company. Limited liability. The liability of the members is limited to the extent of the shares held by that member. Perpetual existence. It is believed that the company will never come to an end. It will always remain active. Common seal. The company will have common seal. Capacity to sue. The company as a legal entity has the capacity to sue others and also be sued by others. Separate property. It can own its own property. So company can own its property. Transferability of shares. Its shares, if in case of a private limited company, a public limited company, it is transferable. In private limited company, it is transferable within few people, but in public limited company, there is transferability which is available to all the shareholders of the company. Now let us go for company versus partnership. What is difference between company and partnership? Governing act of a company is Companies Act 2013. For Partnership Act, it's Partnership Act 1932. Registration in case of company, it is compulsory. In partnership, it is optional. Legal status, company is a separate legal entity, partnership is not. Liability, company has limited liability. Partnership has the partners of the partnership firm have unlimited liability. So unlimited liability means in case if company goes for liquidation, even their personal property can be held responsible. The name of the entity must have, in case of company, it must have words private limited, limited, and in case of partnership, any name as per the choice. Transfer of interest. Shares are freely tradable in case of company, and partnership cannot transfer without the consent of the partners. Agency. Directors are the agent of the company and not others. Partners are agents of the firm and other partners. So partners are agent for other partners also. Powers. Can only carry out objective in the memorandum. Whatever is mentioned in the memorandum, that can be done by the company. Can do anything that the partners agree to do. So in case of partnership, there is nothing like memorandum, and they can do whatever partners agree to do. Now, types of companies. On the basis of incorporation, on the basis of liability, on the basis of number of members, on the basis of control, and on the basis of ownership. Let us look into on the basis of incorporation. There are three kinds of companies: chartered companies, statutory companies, and registered companies. Chartered companies are the companies which are made by the charter of the sovereign. For example, East India Company was a chartered company. It was made by the charter of Queen Elizabeth. Statutory companies are the companies which are made under the law. For example, to make LIC or SBI, there are separate acts. Registered companies, these are the companies registered under the Companies Act. Then on the basis of liability, limited companies are the companies where the liability of the shareholders is limited to the extent of shares held by them. Unlimited companies are the companies where there is no limit of the liability of the shareholders and there is unlimited liability. Guarantee company, these are the companies where the shareholders are responsible to the extent, are liable to the extent of the guarantee given by them. Now, on the basis of the number of members, private companies, public companies, and one person company. In case of one person company, this is a new form of organization which has come under Companies Act 2013. One person company is the company where there is one member of the company and one person holding all the shares. Private companies are the companies where the share transferability is limited. It cannot go beyond. It cannot be held by people beyond that limit. And for example, in private companies, there can be a minimum of two. Maximum there can be 50 shareholders. In private companies there can be minimum of 200 shareholders. In public companies, n number of people, and the shares of the people, shares of the company are held by the people at large, public at large. On the basis of control, holding company is the company which is having more than 50% share of the subsidiary company, and subsidiary company is the company which 51% of shareholders of which company lies with the holding company. On the basis of ownership, government companies are the companies where the ownership, 51% of the shares are held by the government as owner. Non-government companies are the companies where 51% of the shares are held by private individuals or private entities, private persons rather than government companies. And foreign companies are the companies which are constituted outside India and they have more than 50% of the shareholdings of outside India. Now let us find out the difference between private company and one person company. Number of members. Minimum 2 and maximum 200 members can incorporate a private limited company. In case of one person company, minimum 1 is required to incorporate one person company. Number of directors. Minimum 2 directors and maximum 15 directors are there in a private limited company. Minimum 1 and maximum 15 directors are there in one person company. The suffix in the name of the entity, the word OPC, private limited company, shall be put at the end of the name of the one person company formed, OPC. The name of every private limited company must be ended with private limited. Now, nominee appointment. There is no requirement of appointing a nominee in case of private limited company, as there is only one member in the company. The requirement of appointing a nominee arises in one person company. Foreign nationals as members. There is no such restriction in case of private limited company. Thus, an NRI can become a member of the private limited company. No foreigner can become the member of one person company. Board meetings. One board meeting shall be conducted in each quarter of the year, and gap between the two meetings shall be 120 days. In case of only one director, there is no requirement of conducting board meeting, while in case of more than one director, one meeting shall be conducted in each of the half year, and the gap between the two meetings shall not be less than 90 days. Annual general meeting. An annual general meeting shall be conducted within 180 days from the end of the financial year, and there is no requirement to conduct the annual general meeting in case of one person company. So these are the differences between private company and one limited company. Let us go for private company versus public company. In case of private company, there must be a minimum of 2 members and maximum of 50 members. In case of public limited company, there must be minimum 7 members and no limit for the maximum numbers. In case of private company, members of the private company cannot transfer their shares. Members of the public limited company can freely transfer their shares to the person. Private company cannot issue shares to general public. Public company has right to issue shares to general public for raising funds. A private company cannot issue debentures for raising fund. Public company has a right to issue shares for fundraising. There must be at least 2 directors in case of private limited company, and there must be at least 7 directors in case of public limited company. Private company cannot issue prospectus to general public for subscription in shares. Public limited company has a right to issue prospectus to general public. So these are the differences between private company versus public company. Now, private company versus OPC versus LLP. LLP is limited liability partnership. Members. Minimum members in case of private limited company is 2. In one person company, it's only one. Limited liability partnership, it's two. Maximum is 200 in case of private limited company, one person company only one. Unlimited liability partnership, maximum is no limit. Directors, minimum 2 and maximum 15 in case of private limited company. The same member should act as a director in case of one person company, and designated partners as 2. Capital requirement, authorized share capital, minimum 1 lakh in case of private limited company, one person company minimum 1 lakh, and no such requirement in LLP. Capital requirement, paid up capital, no minimum requirement in private limited company, no minimum requirement in any one of them, private limited company or limited liability company. Compliance requirements, annual return filing, board meeting and general meeting. In case of one person company, it's annual returns filing, no board meeting and general meeting as there is only one director, and annual return filing in case of limited liability company partnership. Taxation, taxed at 29%, 29%, 29%. Conversion, can be converted into LLP, private limited company, cannot be converted into private limited company before 2 years, one person company. Limited liability partnership can be converted into private limited company if the members in LLP exceed 7. Now funding, 100% FDI is allowed in private limited company. FDI is strictly not allowed in one person company, and 100% FDI is allowed in LLP, limited liability partnership. So this is difference between private limited company and one person company and LLP. Now, formation of a company. Stages in formation of a company. First of all, let us find out what are first thing is promotion. So discovery of idea is very important. Then detailed investigation and assembling incorporation. So it is very important to first of all generate idea, then detailed investigation of the idea, and then assembling incorporation. The incorporation and registration. In this phase, we will have MOA, AOA made, list of directors made, consent of all the directors that they are ready to act as a director, undertaking to take up the qualification shares from directors, statutory declaration is to be made. So this is the incorporation or registration phase. And capital subscription of rotation, permission from SEBI is required, appointment of broker agents and underwriters, etc. Issue of prospectus after appointment of broker. So broker, agent, underwriter, they will be drafting the prospectus, application for listing, and then allotment. Commencement of business. Now copy of prospectus is to be submitted, return of allotment, minimum subscription is very important, that there should be minimum subscription what is required, qualification shares should be held by the directors, permission for listing is to be required from SEBI, and statutory declarations to be submitted. So these are the stages in the formation of the company. So there are 4 stages: promotion, incorporation, capital subscription of or flotation, and commencement of business, and there are sub stages there. Now, functions and duties of a promoter. First function is ideation. The idea of the business comes from promoter. Preliminary investigation of various matters related to incorporation of company, setting up of the business, etc. Arranging resources and factors of production. Arranging finances. Preparing preliminary documents. Then preliminary contracts with the companies who are going to take with the customers. Name the company. Appointing bankers, brokers, solicitors, and underwriters, and obtain license. So these are the functions and duties of a promoter. Documents to be filed with the registrar of the company, MOA, AOA, notice regarding situation of the office, copy of any agreement, return in duplicate containing the particulars of the first director of the company, list of directors, written consent of directors, statutory declaration, undertaking of a director to take and pay for qualification shares with necessary stamp duty and payment of fees. So these are the things which are these are documents to be deposited with registrar for incorporation. Now with registrar for commencement of business, in case of public limited company, commencement of business is also required. So prospectus or statement in lieu of prospectus, minimum subscription, qualification shares, return of allotment, declaration, and statutory declaration. These things are required to be submitted with the registrar for commencement of the business. Now company documents and their contents. In memorandum, what are there? Name clause is there, registered office clause or domicile clause is there, Objects clause is there, where there are various objects for which the company has been set up, they are mentioned. Liability clause is mentioned there. What is the liability clause? What are the liabilities held by different positions? Capital clause is there. What is the authorized capital? It is mentioned over here. Association of association clause is also there. So association clause gives us about the criteria of association. Now, articles of association, it contains share capital details, lien on shares, call on shares, transfer of shares, transmission of shares, forfeiture of shares, surrender of shares, conversion of shares in stock, share warrant, alteration of capital, general meeting and proceedings, voting rights of members, voting by polls and proxies, dividends and reserves, accounts and audit, winding up directors, accounts, audit, and borrowing powers. So these are things which are contained in articles of association. Borrowing power means who is having the power to borrow on behalf of the company. Now, prospectus. Brief history and prospectus. Capital structure of the company, information about the company management, details about the projects, financial information, general information about the company, commission, brokerage and tax exemptions, board of directors of the company, interest of directors in the assets of the company, and miscellaneous. So these are the contents of a memorandum of association, articles of association, and prospectus. Memorandum of association. It is the document which sets out the constitution of the company. It sets out scope of the company's activities. Basic condition. Importance is it is a basic condition for setup of the company. It is unalterable charter. It provides public document so that public may know for what this company has been set up and what is the motive behind setting up of this company. The base of incorporation. It is a basis of incorporation. Without MOA, no company set up. Guides to directors. So it is a very good guide to director on what are the objective criteria, what is the name criteria, what is the location criteria as well. So it acts as a very good guide to the directors on what company can do and company cannot do. Articles of association. Every company is required to file articles of association along with the memorandum of association with the registrar at the time of its registration. Companies Act defines articles of association of the company as originally framed or as altered from time to time in pursuance of any previous companies. Articles of associations are rules, regulations, and bylaws for governing the internal affairs of the company. They must be described as the internal regulation of the company governing its management and embodying the powers of the directors and officers of the company as well as the powers of the shareholders. They lay down the mode and the manner in which the business of the company is to be conducted. Let us go about prospectus now. Section 270 of the Companies Act 2013 defines as prospectus as a prospectus means any document described or issued as a prospectus or includes any notices, circulars, advertisements or other document inviting deposit from the public or document inviting offer from the public for the subscription of shares or debentures in the company. A prospectus can also include self-prospectus and red herring prospectus. The prospectus is not merely an advertisement. So what normally companies which are going for IPOs and FPOs do, they make the prospectus and then they give it to the depository participants. These depository participants, when anyone comes to them to subscribe the shares or to buy some shares, then they will give these prospectus to those buyers. And then if they find the prospectus interesting, they can invest in the company in the form of shares. The document shall be called as a prospectus if it satisfies two things. It invites subscription to shares or debentures or invites deposits. The aforesaid investment is made to the public. Types of prospectus. So there are mainly three types of prospectus. Statement in lieu of prospectus. A public company which does not raise its capital by public issue need not issue a prospectus. In such a case, a statement in lieu of prospectus must be filed with the registrar 3 days before the allotment of the shares or debentures is made. It should be dated and signed by each director or proposed director and should contain the same particular as are required in case of prospectus paper proper. Deemed a prospectus. Section 25 of the Companies Act 2013 provides that all the documents containing offers of the shares or debentures for sale shall be included within the definition of the term prospectus and shall be deemed as prospectus by implication of law. Unless the contrary is proved, an allotment of or an agreement to allot shares or debentures shall be deemed to have been made with the view to the shares or debentures being offered for the sale to the public if it is shown that the offer of the shares or debentures of or any of them for sale to the public was made within 6 months after the allotment or agreement to allot, or that the date when the offer was made, the whole consideration to be received by the company in respect of the shares or debentures has not been received by it. All enactments and rules of law as to content of the prospectus shall apply to deemed prospectus. The third one is abridged prospectus, section 2(1). Abridged prospectus means a memorandum containing such salient features of the prospectus as may be specified by SEBI by making regulations in this behalf. No form of application for the purpose of any of the securities of the company shall be issued unless such form is accompanied by an abridged prospectus. A company of the prospectus shall, on request being made by any person before the closing of the subscription list and the offer, be punished to it. So these are three types of prospectus. Now, what are the consequences of misstatement in the prospectus? Civil liability, they may go for compensation, damage for deceit or fraud, rescission of contract, there can be cancellation of contract for misrepresentation, liability for non-compliance, there can be liability originated for non-compliance, liability under general law, penalty for contravention under section 57 and 58, a penalty for issuing the prospectus without delivering for registration. So these are the civil liabilities. Criminal liability will be fine of up to rupees 50,000 or imprisonment of 2 years or both, and fraudulently inducting person to invest money, fine of up to rupees 1 lakh or imprisonment of 5 years or both. Now, defense against civil liability. Withdrawal of the consent without issue. So what you can do is, in case if you want to get rid of civil liability arising out of misstatements in the prospectus, first thing is withdrawal of consent. So you can say that I have not given consent to this thing in the prospectus. Issue without knowledge. You can prove that the prospectus was issued without your knowledge. Withdrawal of consent after issue. So even after issuance, I withdraw the consent. Reasonable belief, that there is a reasonable belief that there is reasonable belief of the that you have not been involved into making this prospectus. Statement by an expert that you were not involved and you have nothing to do with the prospectus which has been made wrong. Statement by an official person, extract from the public official document that there was no consent of yours or you were not involved into making of that prospectus which has which has gone wrong. Now let us go for doctrine of ultra vires. Memorandum of association of the company is a basic charter of the company. It is binding document which describes the scope of the company among other things. If the company departs from its MOA, such an act is ultra vires. Let us further understand the doctrine of ultra vires. Doctrine of ultra vires is a fundamental rule of the company law. It states that the object of the company as specified in its memorandum of association can be departed from only to the extent permitted by the act. Hence, if the company does not act or enter into a contract beyond the powers of the directors and or the company itself, then the said act or contract is void and not legally binding on the company. The term ultra vires means beyond powers. In legal terms, it is applicable only to the acts performed in excess of the legal powers of the doer. This works on an assumption that the powers are limited in nature. Since the doctrine of ultra vires limits the company to the object specified in the memorandum, the company can be restrained from using its fund for purpose other than those specified in memorandum, restrained from carrying on trade different from one authorized. The company cannot sue on an ultra vires transaction. Further, it cannot be sued to. If the company supplies goods or service or lends money on an ultra vires contract, it cannot be obtained payment or recover the loan. However, if the lender loans money to the company which has not been extended yet, then he can stop the company from being parting with it via an injunction. The lender has this right because the company does not become the owner of the money as it is ultra vires to the company and the lender remains the owner. Now, doctrine of ultra vires. Further, if the company borrows money in ultra vires transaction to repay the legal loan, then the lender is entitled to recover this loan from the company. Sometimes an act which is ultra vires can be regularized by the shareholders of the company. For example, if an act is ultra vires the power of directors, then the shareholders can ratify it. If an act is ultra vires the articles of the company, then the company can alter the articles. Remember, you cannot bind a company through an ultra vires contract. Estoppel, acquiescence, lapse of time, delay, or ratification cannot make it intra vires. An act legal in itself but not authorized by object clause of the memorandum or of a company or statute is ultra vires by the company. Hence, it is null and void. An act ultra vires the company cannot be ratified even by the unanimous consent of all shareholders. If an act is ultra vires the directors of the company but intra vires the company itself, then the members of the company can pass a resolution to ratify it. If an act of ultra vires, if act is ultra vires the articles of association of the company, then the same can be ratified by a special resolution at the general meeting. The flip side. While the main advantage of doctrine of ultra vires is the protection of the shareholders and creditors, it has disadvantages too. This doctrine prevents the company from changing its activity in the direction agreed by all members. Further, a special resolution can alter the object clause of the memorandum. This defeats the core purpose of the doctrine. Doctrine of Doctrine of constructive notice. The memorandum and articles of every company are registered. The memorandum and articles of every company are registered with the registrar of the company. The office of the registrar is a public office, and consequently, the memorandum and articles become public documents. They are open and accessible to all. It is therefore the duty of every person dealing with a company to inspect its public documents and make sure that this contract is in conformity with their provisions. But whether a person actually reads them or not, he is to be in the same position as if he had read them. He will be presumed to know the contents of those documents. Another effect of this rule is that a person dealing with a company is taken not only to have read those documents but to have understood them according to their proper meaning. He is presumed to have understood not merely the company's power but also those of its officers. Further, there is constructive notice that not merely of the memorandum and articles but also all the documents such as special resolution and particulars of charges which are required by the act to be registered with the registrar, but there is no notice of the document which are filed only for the sake of record, such as returns and accounts. According to Palmer, the principle applies only to the documents which affect the powers of the company. The common law doctrine of constructive notice should apply to the form. To reiterate, the form is a public document which contains particulars of directors, which contains To reiterate, the form is a public document which contains particulars of directors who are the mind and will of the company, as well as the managers and secretaries who are responsible for the day-to-day running of the company. It is a document which affects the power of the company and its agents. Certainly, its purpose must be more than just to provide information about the company's directors, managers, and secretary. Therefore, persons dealing with company should check with the registrar of the company who its directors, managers, and secretaries are at a given time. Doctrine of indoor management. Doctrine of indoor management is an exception to the earlier doctrine of constructive notice. It is important to note that doctrine of constructive notice does not allow outsiders to have notice of the internal affairs of the company. Hence, if the act is authorized by the memorandum or articles of association, then the outsider can assume that all the detailed formalities are observed in doing the act. This is the doctrine of indoor management, or the Turkund rule. This is based on the landmark case between the Royal British Bank and Turkund. In simple words, the doctrine of indoor management means a company's indoor affairs are a company's problem. Therefore, the rule of the indoor management is important to people dealing with a company through its directors or other person. they can assume that the members of the company are performing their acts with the scope of their apparent authority. Hence, if an act which is valid under the articles is done in a particular manner, then the outsider dealing with the company can assume that the director or other officers have performed within their authority. Now, what are the exceptions to the doctrine of indoor management? Knowledge of irregularity. If there was a knowledge of irregularity, then one cannot find this, say this in defense that it is doctrine of indoor management and the company was responsible for its own business. Negligence on the part of the outsider. So, if there is negligence on the part of the outsider, you cannot take this exception. Forgery, in case if outsider goes for any forgery or company officials go for any forgery, then also this is no, there is no exception. This is an exception to the doctrine of indoor management. No knowledge of articles. So there was no knowledge about the articles of association of the company, and acts as outside apparent authority. So when the act is done outside the apparent authority of any person, then definitely the the outside person dealing with the company officials should raise question and should not. This cannot be said as an exception to the doctrine of indoor management. With this, we come to end of first unit of business legislation. I hope you all enjoyed this session. Thank you, thanks, and we'll come with unit 2 soon. Thanks a lot.